Strategic back again. What's going on, guys? This one just came across my desk. A few viewers have sent it to me via email. I appreciate you guys immensely for showing me love. Make sure I'm up to speed so I can keep the rest of you guys up to speed. This is a community. We're family. We're taking care of each other. Big shout out to you guys. Anyway, so we have a motion to continue the suppression hearing. So basically, Stephen Stern's legal team is trying to once again spread out the justice system. They're trying to prolong everything. Like I told you guys, we are not going to be going to trial on the matter of Stephen Stearns versus the people of Florida. This is not going to happen in 2025. At the very minimum, maybe winter, as in November, December of 2025, but most likely winter or spring of 2026. This is one of the jobs of a defense attorney. It is safer for your client to be, especially with a heinous crime like what Stephen Stearns is being accused of. It is more safe for him to be in the local county jail than to be in state prison. It's safer, it's more convenient, meaning that family members, friends of the defendant can visit them more easily because usually people commit crimes in their community. So if you're in a county jail, it's easier for your parents, your loved ones to drive 15, 20 minutes to the county jail to visit you. Now we know that Stephen Stearns' family is in Northport, which is a couple hours away from where Stephen Stearns is being held, but typically people commit crimes within their own community. So if you're in a county jail, it's easier for your family to send you packages, easier for your family to visit you, easier for your family to put money on your books. So the defense attorneys typically try and drag things out. As you drag things out, witnesses get scared, victims get upset that the process is taking so long, people withdraw their statements, people withdraw their cooperation. All this stuff works in the favor of the defense. New evidence is discovered. New experts are found who could testify on behalf of the defense. So many things can happen when you elongate the process, you draw it out, and that is exactly what Stephen Stern's legal team is trying to do. They are trying to drop a ton of motions. After they drop those tons of motions, and I gotta admit, like I've told you guys before, some of these motions are very good. They're very well written, very well thought out motions. He has an excellent legal team. Kudos and hats off to the defense attorneys. They're doing their constitutional duty to give him a rigorous and effective counsel. That's what they're doing. But also they're trying to drag this out. So here's the motion with their recent attempt to drag this out. Motion to continue the suppression hearing. Come now, the defendant Stephen Stearns, by and through the undersigned attorney pursuant to Florida Rule of Criminal Procedure, and moves this court to enter its ordering granting a continuance. Continuance means reschedule. Give me more time. Continuance of the above styled cause as grounds in support of this motion, the defense would show. So now they're going to give the reasons why they need an extension. They need a continuance. 1, the defense motions to suppress hearing are scheduled to be heard on 4/23/2025 at 2 p.m. 2, the pretrial conference is to be heard at the same time as the scheduled motions to suppress. 3, the defendant has been charged with 60 counts of various allegations involving battery, lewd and lascivious molestation, and possession of CSAM. 4, a conviction of any of the above counts may also serve as an aggravator in the defendant's other open case where the state is seeking a death penalty, as evidenced by the state's notice of intent to seek the death penalty filed in this case. Now, I just want to say, you guys, I usually do these shows without my Invisalign, but then I forget to put it in. So sometimes I go hours without having my Invisalign in my mouth, and that is not helping my teeth get straighter. So I have my Invisalign in my mouth right now, so if I sound like I'm slurring a little bit, it's because I have these foreign objects in my mouth, okay? And I just put them in, so it takes a little while for me to get used to them again. All right, so let's keep going. 5, the apparent centerpiece of this prosecution stems from media obtained through a search of a phone attributed to the defendant. 6, on February 6, 2025, the defense filed the 3 suppression motions challenging this exact evidence. 7, since filing the motion, the defense has come into possession of confidential information that may impact the presentation of evidence at that hearing. What? This is huge. Number 7 is huge. You guys hear what I just read? Number 7, since filing that motion, the defense has come into possession of confidential information that may impact the presentation of evidence at that hearing. What is this confidential information they're talking about? 8, the defense will not have time to develop this evidence before the currently scheduled motions to suppress scheduled for hearing on April 23rd, 2025. They're saying they got a game changer and they need more time to develop that game changer, to gather the facts, to put it together so they can present it to the judge. They're saying they've got a game changer in their coffers, ladies and gentlemen. Number 9, as such, defense is requesting to continue these hearings to be reset for a later date. I don't know what they have. I'm speculating. You don't know what they have. They didn't tell us what they have. It may be nothing or it might be something huge for all we know. What we know is that they're saying we have a game changer and we need time to develop this game changer. And guess what the defense can't do? And guess what the prosecution can't do? They can't lie to the judge. They can't say we have super confidential information that will impact this hearing, and then the judge gives them the continuance, and then they come in May or June, and they say, yeah, I got a paper cut when I was looking through the papers. That's why I needed more time. That was the game changer that I got. They can't do that. They can't do that. They get sanctioned, censured, the whole 9 by the judge. They'd also lose credibility with the judge. So if they're saying they have something probative and something of material value to Stephen Stern's case, and furthermore, to the specific motion that's going to be heard or scheduled at least to be heard on the 23rd, they have to have something substantial, something worthwhile. It doesn't have to be something that's going to turn the whole case upside down. It just has to be something substantial. That's deep. Number 9. As such, defense is requesting to continue these hearings to be reset for a later date. Now my nose is stuffy. I'm sorry. 10, that this motion is filed in good faith and not for the purpose of delay. See, that matches up with what I told you guys. You can't just delay. You have to have a real reason. And that's why we have to be very wary about what they're saying in number 7. We have to be wary because you can't lie to the judge. You can't just delay without anything probative or substantial. You have to have a real bona fide reason to delay. So this is huge in my book. This is huge. Let's keep going. 11, the state objects to this motion to continue. Wherefore, the defense moves this court to enter its order granting a continuance in the above style cause. Now, the judge is going to grant this, guys. I'm going to tell you why, because the judge has to err on the side of caution. They have to say, well, you guys are officers of the court. You guys are not Stephen Stern's team, even though they are. At the end of the day, your allegiance is to the criminal justice system and the court. You're officers of the court. And if you're telling me that you have some substantial information that you've just gotten that's going to impact the motion that you have to present on the 23rd, and you're telling me you need more time, it is in the judge's best interest to be fair in this trial to give them that time. So guys, I predict that that April 23rd motion will not happen. It won't happen. I predict it will be rescheduled, but I am concerned about number 7. I am concerned about number 7. You can't say something like that and not have the meat. You got to have the goods if you're going to say something like that in this type of motion, asking for more time. Because if not, you lose credibility with the judge and you also face getting in trouble, because you're misleading the court. And from what I've seen so far, this defense team is doing everything in their power to help Stephen Stearns, which is good because we want him to get effective counsel so that he can appeal. But there's nothing that they've said so far or done so far that could be construed as unethical. They've done their job by the book, by the numbers. We may not like it because we know that Stearns is guilty and we want him to get justice, but they're doing their job. None of their motions have ever bordered on misconduct or even just being mean. And we've seen attorneys be mean before. We've seen attorneys be mean to victims, be mean to the criminal justice system, act like it's their eternal duty to represent their client, which is not. They just give them good counsel. That's it. But we've seen attorneys go above and beyond to somebody that we all know to be just super guilty. He's on fire guilty. These attorneys haven't done that. Everything they've done is professional, by the book and by the numbers. So if they're saying that they've got a number 7, I think we need to be curious as to what number 7 is. Not concerned, ladies and gentlemen, because we know what the evidence is against Stephen Stearns. I'm not saying we should be concerned. I'm saying we should be curious as to what they got going on, because the only thing I could think of is what they got going on is something that's going to implicate somebody else possibly. But it also might show some misconduct on the side of the police department, because this is a motion to suppress what they got from the phone, and they've said that they've received confidential information that will throw this motion on the top of his head. So it might also involve some type of police misconduct or not adherence to policies, or, as we've been discussing in the last few weeks, best practices. Best practices. Anyway, guys, see you guys on the next one. Strategic is out of here. We haven't set up the outro yet, guys. Remember, this is a new computer that you guys helped me purchase and build. So we don't have an intro and an outro set up on the computer yet. That's why I haven't been playing them. But rest assured, by the end of the week, we'll have the intro and the outro set up. So, guys, make sure you become members and Patreon. We appreciate you guys for supporting the channel. Make sure you like and you share this, guys, so we can get those subscriptions up. Like and share this. Like it and share it on your Facebook, your Instagram, your Twitter, aka X. Share it, pump it. We love you. Peace.